Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. We have one case on for en banc hearing. It's 22-4489, United States versus, and I hope I'm pronouncing it right, Chaudhry, but if not, you can correct me. Mr. Price.
Good morning, Your Honors. May it please the court. The police had no reason to suspect Mr. Chaudhry of a crime, but they got a warrant to search his location history data, along with the location data of millions of other Google users, all without probable cause, not for Mr. Chaudhry, not for anyone. The warrant relied on generalizations and statistics about cell phone use that could apply in any case. It cast a digital dragnet that gave police discretion over what to search and seize. It was so overbroad and unparticularized that it was a modern-day general warrant. No reasonable officer could have believed it was constitutional. It was like making a landlord search every unit of a million-story apartment building, or making a bank search every safe deposit box for stolen jewels, or making Microsoft scan every email for an incriminating phrase. Valid warrants don't work that way.
So is there a geographical space limit on what was searched?
There was a geographic limit on what was seized. In order to obtain the information about the devices near the bank, the government required Google to conduct a search of every Google user with location history enabled. The government, Google in this case, said that was at least numerous tens of millions of Google users. And we know from
Isn't that anytime you subpoena the records of a credit card company or a bank or something, they have to go through their files to find what's being asked for.
So I think
in this case, they were asking for data about accounts within a limited geographical area and a limited time, 1 hour and a geographical area of what, 150 meters, and conducting an investigation to see what kind of markers the criminal may have left behind, and those spaces and time are related to where the bank robbery occurred. I mean, isn't that like going to a scene and picking up casings and fingerprints and boot prints and credit card things in the area to investigate a crime? It seems to me the search, if the search was very broad, the electronics affords that, but the geofence can restrict the search to a context that is traditional in any crime investigation, which is to find the markers left behind by the criminal near the scene of the crime. I think in response to the question just posed to you, you have to recognize that the search was not of all of Google's files. They had to go through the files to select the data to fit the response, but the response, the search request was for information of markers left behind within 150 meters of the bank and 30 minutes before and after the bank was robbed.
So I think it's important to point out two critical issues here. First, this was not Google's data. This was personal data that belonged to each Google user who had location
It
history.
was Google's records.
It was not.
Google's records. He consented to give it to Google.
They are not Google's records, Your Honor. Even
Well,
Google
you
says
know,
they're not Google's records. Google says they are not business records, that they are akin to a personal journal. They are treated as user-generated content. They are kept in a user's account alongside their email and documents and photographs and other digital papers and effects that they have. When this
It's like
information...
saying my bank records are not the bank's, they belong to me.
The bank records are business records, Your Honor. Those records are created by the bank in the course of their daily business. They are their records, and so there's a difference between sending a
So
subpoena
these
to...
aren't Google's business? I mean, Google is in that business, aren't they?
These are not Google's business records. Google is very clear. It's in giant
Well,
bold
they
letters.
sold
at the-
him on the phone to turn the records over, to get the records. He voluntarily gave the records to Google. And they use them for other purposes,
So
for marketing and things like that.
Google goes to great lengths to say that they protect users' data and
Oh,
do
I'm sure
not
they
give
do, and so do banks.
personally identifiable
So do a lot of
information to
businesses.
anybody.
That's the best way to do business is go to a lot of, be cautious about maintaining people's privacy. But here you got what they're looking for. They know a crime occurred. A bank robbery. At gunpoint. $195,000. Folks on the floor. They tell her, scared to death. A bank officer scared to death. Civilians or customers of the bank scared to death. And the robber had a phone. So there's certainly not just probable cause, there's absolute evidence of a terrible crime. The only question is who did it.
Your Honor, in this digital age, when people have cell phones attached to their hands like an appendage,
Add to what Judge King said, the detectives here were completely out of leads. If they hadn't had this geofence warrant, this individual would never have been apprehended. As Judge King points out, he went into the bank vault and took $195,000. And if we invalidate all these geofence warrants, next time it's not going to be just a bank robbery. It could be a murder, it could be a terrorism attack, it could be something very terrible. And in many, many cases, the geofence warrant is required because the traditional leads of forensic evidence and witness testimony, they don't have it to wrap up the case. And what you're asking us to do is to essentially let this individual go free by the exclusion of relevant evidence. And how many crimes are going to follow and be unsolved because this tool of last resort, when other investigative tools fail, this tool of last resort has been sweepingly, it's what you're asking us, not on it as applied matter. You're asking us as a sweeping declaration to say that in all circumstances, geofence warrants are impermissible. And that is a broad ruling.
to be clear, Your Honor, I am asking this court to hold this warrant unconstitutional, but I understand Your Honor's concerns. In this particular case, it's not at all clear that law enforcement did exhaust all traditional investigative leads.
Well,
Well,
there-
does the
if you
significant,
take the concurring opinion from Judge Hope from Fifth Circuit, the only circuit that has addressed this, and gone squarely to determine that this is a violation of the Fourth Amendment, very strongly. Judge Hope writes in there that you're gonna have instances in which the police may not do what it's supposed to do, or may not be able to get the information, but our framers knew that when they put the Fourth Amendment there. If you wanted to have instances where every time a crime could happen, you would have no Fourth Amendment. You would simply just go and search. But there is a search here. The problem for this court, and any court that addresses it, is understanding the technology. It is when you begin to say things like, well, it's location services as opposed to location history, and there's no difference. And you don't quite grasp the significance that, yes, there was some geographical limitations, but it included everything around it. Banks, churches, all kinds of people. It goes into a sensor bank. And it goes in this sensor bank, it's just data on every human being that's walking in that area there. They're not involved in this. This is searching. This is just doing a wide search. The United States Supreme Court has already spoken to it to some degree in Carpenter. You could have every argument you just had right there in Carpenter. Why in the heck can't they get the cell site information in Carpenter? Because the police couldn't do their job without it. But nonetheless, the court said there is a privacy right, there's an expectation. That's what we're struggling with here today. And we can grapple with whether we're going to try to do the police's job of doing this, or are we going to require them to simply follow the strictures of the Constitution to do that which is required under the Fourth Amendment. Doesn't mean you can't do your job. It means you need probable cause with particularity to be able to get information. And when we as a court begin to rewrite the Constitution so that we can allow law enforcement officers to do that which the Supreme Court has already told us they cannot do, that's a problem. That's a major problem, what we're dealing with here. But it is the understanding of the technology here, whether it's Carpenter or whether it's a beeper attached to the back of a car or whatever is going on in here. How far do we go? Because it does not stop here. Now, end of the day, in this case, this court found there was a good faith exception. And it simply said, okay, there's a Fourth Amendment violation. Mr. Chartre's gone nowhere in this instance, as did the Fifth Circuit. They found there was a good faith exception to this matter. What it says is, the next time you do this, do it in a way in which it has that particularity. And to add to it, for all those who think the sky is falling, Google's not doing this anymore. This is not, you won't be able to get this information. Whatever this tool you think is so important, whether Google owns it or not, they are not doing this anymore. They've changed because Google wanted to get out of the business of being law enforcement. We don't survey, we don't ride by houses and put infrared lights on or lights onto a house, see heat in it, and says, okay, we know you got marijuana, we go get it. Supreme Court said you can't do it. Even though it turned up marijuana. So the result does not drive the means. And the manner in which we are discussing this today, that's exactly what's happening here. If we're gonna do the police's job, then let's just declare the Fourth Amendment not existent and just say, anytime you wanna do a search, just do it. And use all kind of legal nuances to avoid what is truly here under the case of Katz and all of the cases that followed from the Supreme Court of a reasonable expectation of privacy, trying to protect the rights of individuals. Mr. Chartre is not the only one implicated here. There are hundreds, and they have to comb millions and millions of people who are using it to eventually find out what's in that census database. And that tells you nothing. That just tells you there's a whole bunch of people out there. So there's a lot of other implications here beyond this. The police had a job to do. A woman was frightened at counters. Happens in all cases. But that's not the job of a judge in interpreting the Constitution, which protects the rights of individuals for unreasonable searches and for an unreasonable expectation of privacy and stuff, which the Supreme Court and squarely a unanimous panel of the Fifth Circuit, including Judge Ho, who concurred in it, agrees that there is a Fourth Amendment problem here, notwithstanding the good faith exception.
Your Honor, I think in the first instance, everything that we can say about location history and taking a tool away from police could be said about every other technology the Supreme Court has considered as well. As you mentioned, Carpenter, the court decided that there should be a warrant requirement there. In Riley, the court said you need a warrant requirement, even though that might slow down a police investigation. Jones, the same consideration.
So can I ask you about Riley? So the tagline at the end of Riley is, if police want to search the contents of a cell phone, they have to get a warrant. But of course, the police got a warrant here. And I guess it seems your position on warrants is a little slippery to me. Is your position that all geofence warrants are invalid, which is what the Fifth Circuit said, or that this geofence warrant is invalid?
Our position is that this geofence warrant is invalid.
Okay, give me an
I-
example of a geofence warrant you think is valid.
I do not believe, Your Honor, that it is possible, at least in this construction, to have a geofence warrant.
I'm not asking in
that
this
would be
case. Give me an example of
constitutional.
a geofence warrant in a situation that you would think is constitutional, so that I believe you when you tell me that you don't really believe that all geofence warrants are unconstitutional.
No, I guess, I apologize for being unclear. We do not believe that it is possible to have a constitutional geofence warrant if it is operating in this fashion.
So the J6 warrants, for example, were unconstitutional?
Yes, Your Honor. I think it is impossible to get away from the initial search of millions of people. At the end of the day, this is a search. You're searching the haystack for a needle. You can describe that needle very particularly. You can describe its shape and its color, but you still have to search the whole haystack to get there. So
Well, is that a search, or is that Google's process of getting to the search? So is your position that the actual search is when they look at the millions of people who have location history clicked on their phone?
Yes, Your Honor. Google here is acting as a government agent, as in Skinner, the railway executives. Everything that they are doing in terms of searching and compiling this information is only being done because of this warrant. They don't have this information just sitting around.
And that's what the
ready to
bank
go.
does when they issue them a subpoena. What if you say geofence warrants are bad, they're unconstitutional? What if a grand jury, federal grand jury up in Richmond, and the prosecutor, United States Attorney in Richmond, and goes to the grand jury and discusses this case? Now, you don't know what goes on in the grand jury, it's all secret. But I can tell you from experience, they go in there and they discuss the case, and the grand jury and the U.S. Attorney decide to subpoena that stuff. Issue a grand jury subpoena. Subpoena duces tecum to Google. Come and bring with you. Now, what about that?
Once again, Your Honor, these are not Google's business records. It is different from a bank if you're asking for transaction records.
They got them.
They did in fact get them.
They got them while they were conducting business,
They-
and they're the custodian of them.
They
There's
got-
no other place to get them. So the grand jury issues the subpoena to Google. You say is that constitutionally flawed?
Yes, Your Honor. This,
And so they can't, the grand jury of the United States cannot subpoena this.
well, I guess I want to be very clear.
So that's an investigative tool.
Law
I
enforcement.
mean, a lot of people would say in this situation, if they look at this detective ought to be given an award, Detective of the Year or something, for finding this bank robber,
So we are not saying that.
catching him, putting him in prison, where he belongs.
Law enforcement can get access to location history data. We are not saying that law enforcement cannot get this data. It's simply, we are simply saying that they must do so in a way that complies with the Fourth Amendment's
Well, would
particularity and
the
probable
grand
cause.
jury subpoena method satisfy that?
No, Your Honor, I believe probable cause and a
So
warrant
the-
is required to get location history
So the
data.
grand jury can't issue a subpoena unless they already have probable cause.
This is
A grand
user,
jury is an investigative body, and it's also a charging body, but they only charge after they get probable cause. Do you understand how they work?
I understand what you're asking, Your Honor.
Basic stuff. So they're investigating, an investigative grand jury. Why couldn't they do this?
Again, these are not Google's
And if they can
business
do it, why
records.
can't the magistrate judge do it? And the officer, the court?
We
I mean, they
believe
could
that a
go to
warrant
the-
is required for
And
this
the
type of
district
data.
judge rather than the magistrate judge.
Let
So
me
is
ask
it
you
correct?
just along that same line, if the subpoena said give us the data. These are historical data that exists, so it's not an ongoing surveillance or following of a citizen. These are historical data. And the subpoena says we would like the historical data of cell phones used within 10 feet of a bank during a period of 10 minutes before and 10 minutes after the bank robbery. Give us the data you have. And Google goes through and puts those limitations on its search of its data and comes up with data that implicates at least some of one of the data implicates the criminal. Is that, you think that violates the Fourth Amendment?
I do, Your Honor.
Well, then you can't have any investigatory subpoena. You go into you have a crime committed in a Walmart, and they go in and they subpoena the cash register records of 10 minutes before and after the crime was committed. And they're going through to see if they can identify. I mean, this is investigative. They go to the coffee shop. A guy presumably went into the coffee shop, and they subpoena the records of sales of coffee during the period. Or they go outside and search the trash can for fingerprints. Do they need subpoena to go to the trash can?
So I think, first of all, in this case, there is a big difference between.
It's a big difference because
and
the
matters.
data they're searching is a huge collection of data. But they're
matters.
not searching the individuals. They're looking for the criteria, which is one, within 150 meters of the bank, and two, within a half hour before and after. Now, that's very limiting. So you put those data in, and you come up with a very limited list. That's what they did in this case. And you're saying that's unconstitutional, which sounds to me like almost every police investigation that we've conducted in this country would fit those criteria. I mean, this is, the problem here is created by the enormous breadth of the data bank. But it seems to me if the data requested are very narrow, it's nothing more than asking the bank for the bank records. And the bank goes through its files and combs all its files to see which one belonged to the criteria being searched or requested.
Would a geofence warrant ever be permissible?
He says not.
Would you, I mean, no matter how serious the crime, no matter how imminent or devastating a terrorist attack, your position that under no circumstances, no matter what the loss to individuals and society from the criminal act might be, that a geofence warrant is off the boards? Never, never, never can a geofence warrant be valid in your judgment. Is that correct? Is your position that broad?
Let me take a stab at answering both of these questions, because I do think it.
I
if
understood
I
you
may.
to already say that.
I have. I do believe it is not
But
possible
you need
to
to address that
construct.
question because they're asking a very important question. And I'm not so sure you're correct on that J6. When you're dealing with a particularized situation, if you have a vacant house out in the middle of nowhere and you have someone that robs it, and that geofence just shows those who arrive, that's particularized. That's what they're getting at. And the differentiation, that's not what you have here. You don't have that particularized location information, the particularized suspects. That's what the Fourth Amendment requires, it's the particularization of it. But don't walk into this trap of saying, no, you never can get one. Surely you can. If the geofence showed, as I said, a vacant house out in the middle of nowhere, it shows nothing but people going to that house and they were robbers, surely that's gotta be an instance where that's permissible, that you can do that. That's not what you have here.
The problem with that is that you're not searching just the area around a cabin in the middle of the woods or the area around the Capitol. You are
I am
searching.
getting no guidance from you as to when a geofence warrant would be permissible and when it would not be. I don't understand what the guidelines are. I don't understand what the circumstances are, or the particulars are. You're coming across to me in the briefs and everything, you're saying that this whole tool is so impermissible and so violative of the Fourth Amendment that it can never be utilized. And that strikes me as a very far-reaching position.
And he's
Your Honor-
correct if that's your position, but if you focus less on the breadth and more on what Carpenter calls the intimate details that it picks up, that may be where you're going on this.
I think it is certainly capable of revealing quite intimate details, even.
But at step one, there's no intimate details revealed. There's no identifiable information whatsoever. So why is it even a search at step one?
So I think it is important to treat this warrant as a whole. The government certainly treats it as a whole and has repeatedly argued that the three-step process is constitutionally meaningless.
The three-step process is a Google process. It's not a constitutional process.
It
At
is-
step one, Google turns over information that is completely anonymized. Isn't that right?
It is also eventually de-anonymized.
Later, but at step one, the initial information that's turned over, how can that be a search when there's no identifiable information?
I disagree that it's not identifiable either.
At step
Your Honor.
one, it's identifiable?
The government has said that they are capable of obtaining a subpoena post-step one to obtain all of the identity information for everybody in step one. They also
So perhaps
argue-
at that point, that becomes then a search.
They also argue, as the government attempted to do in this case, to obtain step two and step three data on everybody returned in step one. So the idea that this is somehow anonymous is a bit of a fiction in this case. And especially when you get to the data in step two, which puts people
So
in
perhaps at step
constitutionally
two, then it
protected
becomes a
spaces.
search, and perhaps at step two, there would need to be a warrant. But at step one, when the millions of, as you were saying, bits of data are reviewed and then some number of them are turned over, perhaps at that point, that's not a search.
Even at step one, Your Honor, you are revealing people's locations inside of constitutionally protected spaces. And even for a short time, a single trip can be incredibly revealing. So the idea that
Well, I
this is
guess you're saying that every camera on the street corner that picks up a person walking into the bank cannot be subpoenaed.
a surveillance camera outside the bank, Your Honor, is so far from this situation.
You
it
just
could
made a
absolutely-
statement that even a single piece of data that identifies somebody is still too broad a search because you have to look through too many data.
I
get
believe
there.
even a single trip can be incredibly revealing. And honestly, whether that is done in real time or
I mean, the
historically.
reality of police investigation is to collect data of all kinds that are left behind at a crime scene. We're looking for fingerprints, we're looking for shell casings, we're looking for notes left behind, we're looking for camera, video and so forth. They collect all of these data. These data are broad data, they don't necessarily link somebody up, but as they do the investigation, it starts pointing to more particularized people. The situation with electronic data, he left behind data while he was there, and those data are being searched. Now, the issue you raise is a correct one. That is part of a huge data bank, but that doesn't make it an illegal search if you say simply because you have to go to a large data bank to get the particularized data relevant to the bank robbery. In this case, identifying the persons who were within that small geographical area at that time is a very particularized deal. And when they search for that, they're not looking at individual human beings, they're looking at data, unidentifiable data that meet those criteria. Once those criteria are met, now you have a very confined data bank, you have an investigatory territory that can be identified, that contributes to the investigation of the crime. But to just blanketly say, because the data bank we're looking at is too large, we can never collect data on a particularized location at a particularized time. It doesn't make sense to me in terms of what we accept as police investigation. I'm happy if you want to explain how, but
Happily. So here, what we're talking about is not searching the area around the bank. The
No, you're
police were-
searching the data left behind during the bank robbery.
It was not left behind at the bank, Your Honor.
Sure it was. It was left behind. While he is in the bank, he's got a phone that's sending electronic signals that are recorded at that point. And those data would help solve the crime. And if you can particularize the request and the investigation to an area and a time that is relevant to the crime, that's traditional crime investigation.
So here, it is more like searching every house in the entire neighborhood.
They don't search every house.
But that is the functional equivalent.
Just as Judge Berner says, it's just unidentifiable data, and the data aren't even searched. The data are separated by the criteria. So the criteria are 150 feet of this location, and as you know, the government gave the very specific location to the second on the global thing, and they gave a specific time, 30 minutes before and 30 minutes after. That is a very narrow group. Now Google puts those restrictions into its data and pulls out those that meet it. Now we have a very finite and fairly small group of data from which they even required further particularation. But even the first step is not a search, except to the extent that you search for the file for Niemeyer in the ends in a file cabinet. You go down all the ends and you pull out, look at the ends until you get to see Niemeyer, and then you pull it out.
Except here,
And then
Your
they
Honor,
find I committed a crime.
except here, they're not searching by last name.
No, they're searching by space and time.
And the only way to do that is to go inside each house and see if the
They
data
don't go
matches
inside each
that
house. They
criteria.
separate the data.
They have to search.
Unidentifiable data at that point. They're basically putting in two criteria, and in this case, we actually have the record of what they came up with. And that was still unidentifiable. The next steps were to particularize more, and in the final steps, very final steps, when they had the most particularization, then they put names to those. Seems to me that's very careful police work, protecting the interests of every other person. I would like to know, and this question's been asked to you, if you think there is any possibility we can search electronic data to discover a crime.
Electronic data can certainly be searched in order to solve a crime. The only thing that we're saying here is that it has to comply with the Fourth Amendment's
No, you
particularity
said,
and warrant
you
requirements.
say the geofence warrants are unconstitutional. You said that exactly. Unconditionally, you said that.
I said, I don't believe there is a way to make a geofence warrant constitutional if step
They're
one
unconstitutional.
searches
You're
every
saying they're
house in the neighborhood.
That's, Judge Wilkinson said, that's about as broad as you can get. The geofence warrants are off the table for investigating crimes, investigating anything, regardless of how serious the crime, terrorist activity. Pick it up. This is a terrible crime. A bank robber with a weapon walking into a crowded bank, scaring people to death.
Do you realize just how broad your position is? What the full implications of it are? I don't think you do. I don't think you realize just how much you're taking off the table in terms of the tools that law enforcement can use in the most serious of situations. Just think about it. I don't think you understand just how broad the proposition you put before us is.
And perhaps your answer might be, we don't understand how broad the implications of what is being asked to be done. Google is not capable of storing information in any specific way. It doesn't do that. It does not know who the users are in its location history. It has 592 million people in a census vault. Just like you got people in this room, just like you got people in Richmond. You know, if a crime is committed in Richmond, Virginia, well, somebody in Richmond did it, because we got 95 here and we know you're here. So what can you do? Start sweeping, and that's essentially what you're doing. You start narrowing it down And you fall into Judge Niemeyer's situation, well, you can find this location. We believe they're in this area here. There's 1,000 people over here. Let's look there. Let's narrow it in, narrow it down. That's a search. And that's the problem that's here, is the broadness is just what's happening here. That's why Google didn't like it from the beginning. What we have done is we have location history. Oh, that's all they have, location history. And it's of millions and millions of people. Then you begin to say, well, can you comb through it till we get to where we want you to be in this instance? And nothing is particularized about it, because in the carpenter factors that are there, all 5 of those that are met, those factors are met there. You can't show that it's this individual or that individual had the phone or anyone. You have a huge swath of people. And if we let this go, the broadness is going to be from this. And the Fifth Circuit recognized it. Part of what we're dealing with here is we're dealing with judges who are confronting new technology and want to apply the most simplistic principles to it. To say, you mean to tell me if I find that it's right here and this guy is in this area, we can't use that data? That's not what's here. It's not a particularized data. It's 92 million people. Now, that's all you have. That's what Google has. It doesn't do anything with that. Then it becomes a law enforcement thing. Well, do something with it. Start searching Richmond until you find within that 92 million people, 592 million people, who is likely to be in a position of it, who might be, who could be, who knows, no probable cause, until ultimately you find something that comes of interest to you, and then you get to it. It's a reverse way of doing it, and it's what the Constitution doesn't allow. But if we do this, we're the ones who are going to be broad in it, and the broadness is not just on Mr. Chaudhry, it's on every citizen who is under the Constitution of the United States. You just deprived them of an individual right that exists in the Fourth Amendment. You, every one of you, sitting in here right now, can have your location data, I don't care where you are, and it can be put in a great pool, and then you have no privacy whatsoever.
Mr. Price, I think you might want to sit down after that.
Thank you, Your Honor.
Chief, can I ask one
Oh, sure.
factual question
Go ahead.
before he sits down, just to make sure that I'm
Absolutely.
understanding the record here? Is it correct to say that in order for this localized history to be collected and revealed by Google, that Mr. Chaudhry had to opt into that?
Location history is an opt-in feature. I use opt-in and basically air quotes.
Right.
It was, in our position is it was not meaningfully voluntary, that the opt-in screen, so to speak, did not meaningfully convey information about the nature of the information that would be collected.
But if he had not opted in, would his data have been available under this geofence warrant?
No,
And neither would anybody else within that area who had not opted in?
correct.
All right.
And only approximately a third of the people that have these cell phones opt in.
To this particular service, Your Honor, there are other location
But this
services that
location
are
history.
common.
They opt in, about a third of them. So he's in the minority of the people that opt in.
I think we're talking about location history specifically here, but location services on a phone are a pretty essential feature of modern cell phones, as the court said in Riley when discussing why they were so sensitive. So I think, you know, here, location services, mapping, is a quintessential function of a cell phone. And the requirement is not that people use location history specifically any more than the court considered whether, you know, everybody used T-Mobile in Carpenter. The proper comparison is to services of a similar variety, and I would submit that most of us use location services and store that data in some way. So we're talking about location history here, but that would be only the beginning.
It's hardly an informed situation. I mean, when you deal with it, the Google employee says, this is something, they say is very limited, is partially hidden. You're gonna get it when you just open your phone up. People don't even know it. Who knows that the Google has information potentially going to back base that could be turned over to the government? That's not a part of anything here. Most people in here don't even know they got it on or not.
I-
There's nothing voluntary about this.
The opt-in screens, Your Honor, did not even say the words location history. They said, and we're not even clear on this, but they either said saves a private map of where you go, or said saves where you go on your device with a single button to click in. There was other information that was hidden behind a second screen that other people were not required to view. But we're really talking about one sentence on a pop-up
Well,
when
if you
setting
know,
up Google Assistant in the middle of the night.
everybody is not that ignorant about cell phones. On their settings, there's a privacy thing, and you can opt in on every program. You just go to privacy and you opt in or out as to whether they're going to trace you. I've done it, and I'm Luddite, and I'm sure there's an indication that when 2/3 of the people don't opt in, there's a lot more information about that in the public. And if this bank robber was a thinking bank robber, he'd leave behind no evidence, no fingerprints, no cell data, nothing. He just wasn't a thinking criminal, and he made his the ability to find him and convict him easier than maybe somebody else in a similar circumstance might have done.
I think it may not be as easy as Your Honor suggests.
Well, I've done it.
I think it's certainly gotten more attention since this case, but we have emails from Google engineers saying that location services and location history controls are difficult enough and confusing enough that they appear designed to ensure that nobody figures out how to work them. In that sense, it was a bit of a lobster trap. Very, very easy to opt in with a click of a button in the middle of the night, and very, very hard to figure out from that point on that you've got it enabled or how to turn it off. And there's no, once it's turned on,
Apparently 2/3 of users figured out how to do that.
I think it may be possible that they didn't opt in at the first time or clicked no. But what we're talking about here is collection that occurs every 2 minutes, regardless of what you're doing on the phone. You may be asleep, you may be in the shower. At least when you're talking about cell site data, you're making a phone call or you're receiving a text message, something to indicate that you might be disclosing this information. Here, it's a click of a button, and then forevermore, every 2 minutes, your precise location logged without any interaction from the user or any warning that this remains enabled.
Thank you, Mr. Price.
Thank you, Your Honors.
Mr. Judicial? The good news is I checked my docket, and the case is United States versus Chaudhry, not United States versus Niemeyer. So,
Well, I was waiting for that. That was helpful.
Good morning, Your Honors. May it please the Court. I'm Nathan Judicial on behalf of the United States. There are 3 bases on which this Court can affirm the District Court's denial of Mr. Chaudhry's suppression motion. His lack of any protected privacy interest.
Can you put that microphone a little closer to you? Speak up.
Yes. His lack of any protected privacy interest in any of the location information disclosed pursuant to the warrant, the validity of the warrant, and officer good faith reliance on the warrant. So we very much agree with the panel's analysis of Mr. Chaudhry's privacy interest, but given that the Court thus far has focused on the validity of the warrant, I'd like to begin with that.
Do you understand the panel decision is vacated?
I understand that, Your Honor. I'm just endorsing its analysis.
We're back to the district court's opinion.
Yes, it's entirely appropriate to affirm on any of those bases. The warrant here complies with the Fourth Amendment because it was supported by probable cause and because it specified its objects with particularity. The affidavit established that there had been a bank robbery, that the robber appeared to use a cell phone, and then explained why it was a reasonable inference to believe that Google would have information related to the robbery, and that information included not only identifying the robber, but also the investigators were interested in more of a spatial temporal understanding of the crime scene, identifying witnesses, and there was more than a fair probability that the warrant would identify evidence of the crime. it specified its objects with particularity because it included narrow time constraints on the information that could be obtained, and it also included an appropriate temporal limitation.
Limitation is not the same thing as particularity, is it? Is it? You said, limitation, is that particularity? I mean, for example, limitation is just this room. Is that particular to any of us in terms of a crime?
The particularity requirement requires that the warrant specify evidence of crime and that it establish probable cause to believe that that evidence will be at the place searched. And so I think
Counsel?
the limitations.
I'm sorry, I didn't mean to interrupt you, but are you assuming for purposes of this answer that the place searched is Google and not the 19 people whose data were involved?
I think that.
Because if you're saying this was enough to justify a search of Google, I totally understand what you're saying, but I don't see how it's enough. You're trying to sort of put to one side the question of who has an expectation of privacy and was this a search. But if you conceive of it as a search of the 19 people who made it to step 2, then I don't see how that is justified by saying there was a likelihood they would find evidence relating to the crime when they got this stuff from Google.
I think that the everyone whose information they got was, within the limits of the warrant, going to be evidence.
So you think there was probable causes to all 19 of those people?
So I don't. So the rule. So I think, and this is, I think, is where the district court went wrong on this. The probable when the Supreme Court said in Zurcher v. Stanford Daily, which involved a warrant to search a newspaper premises.
Right, but that was as to the Stanford Daily's privacy interest. So they stood in the same shoes as Google, and I'm giving you that. There was probable cause to go to Google and to believe that Google would be able to give them evidence of the crime. But the kids in the Stanford case, they had no privacy interest in the photographs that were taken of them out in the open. So there was no sort of third party to worry about. But again, if we think there was a search as to those 19 people, I'm not seeing how Stanford Daily helps.
I think with respect to those 19 people, they're potential witnesses to the crime, and the warrant was drawn in a way which was limited it to people who were in the area of the crime at the time of the crime. So basically, the warrant was after the bank robber. It was after his co-conspirators. There was some evidence that there would be co-conspirators. His ransom note spoke of his boys on the outside watching, and it was after witnesses. And all of those things are appropriate.
Wait, did the officers, am I correct, the only person whose personalized info they ever got was Mr. Chaudhry's?
They in the 3-step process. At the step 3, they went for identifying information for 3 people. So and that's basic subscriber information.
One of whom was the perpetrator?
One of whom was the perpetrator.
Were the other 2 people ever interviewed?
That's not in the record.
Did we ask them if they, I mean, you just said it could be justified that we're looking for witnesses. It seems a little strange that we didn't actually go and find any of those witnesses. It just so happens the only person we seem to have gone and found is the perpetrator.
I mean, had the case gone to trial, I don't know who the witnesses would have been of the people who were present at the crime scene. But I think that the issue when we're seizing evidence pursuant to a warrant isn't like, another thing we know from Zurcher is there's no necessity requirement for the evidence that we're getting pursuant to a standard search warrant.
But wouldn't a warrant need to be more specific to say that you're looking for witnesses or co-conspirators? Here it just says the bank and a cell phone.
That's in the affidavit. That's among the things that we are interested in. And so the magistrate the magistrate in this case looks at the warrant and
It was a state magistrate, right?
Yes, that's correct, Your Honor.
State court warrant.
That's correct.
Chesterfield County, Virginia.
That's correct, Your Honor. And so the magistrate looks at the affidavit and the evidence that we're going to seize and makes a determination that the information which falls within the scope of the warrant is evidence of a crime. And here I think that's a very reasonable.
Mr. Judge, can I follow up on Judge Harris's question? So at step 2, when the warrant is narrowed to the 19 individuals at step 2, we're still talking about anonymized data at that point, right?
That's correct, Your Honor. I mean,
is that legally significant? I mean, we don't know who these people are, so the police don't know. It's only at step 3 where they actually get the identifying information.
I mean, I think for purposes of validity of the warrant, the question is whether it's evidence or not. I mean, I think the differences between the anonymized information and the identifying stuff may be relevant to the ultimate question of whether people might have any expectation of privacy infringed. But anyway.
Did you answer that question? I didn't understand. Did you answer the chief's question in terms of how do you get from 19 to 3? The 19, what was it about them? What did you have about them?
So the way the warrant worked is in step 1.
I know, we'll get through that. I'm trying to, it's a lot of, we don't have much time. Other people want to ask questions. How do you get from 19 to 3? That's what I'm asking. What is the particularity that drove 19 to 3?
So the warrant had a 3-step process in which the officers were instructed to look at the information they obtained from Google and decide what additional evidence they needed beyond that. They're trying to make determinations.
So they decide, like, they get the whole batch, and they decide, I'll throw you out, I'll throw you out, I'll throw you out, throw you out. So the 19 weren't thrown out in that cut?
I mean, the officers are seizing evidence of crime as they go along. It's any time officers execute.
Evidence of crime? What you have evidence right now? People using their phones. These are people using their phones. I mean, they're citizens, non-citizens, whomever they might be. That's what you have. You winnow it down to, I'm talking about the 19. What was it about them that made them suspicious that would be consistent with your particularity? That's what we need to get to. That's the part I don't understand. The 19, that's what the detail is. How were you able to get from 19 to 3 with the particularity you had as to a crime? As a probable cause or particularity, right now you have people who are just using a phone in your perimeter. But the 19, tell me, how did you get from 19 to 3, and what did you know about them as particularity?
The warrant instructed the officers to examine the data from the first step.
And they did that. Tell me, what did they find out that made them leave from 19 to 3?
I mean, at that point, they're trying to make assessments about what the role of people are in a crime. So, for example, if there had been a co-conspirator involved, there's a reasonable probability that they would have met up afterwards, at some remote location or something like that. So they're looking at the evidence they've obtained so far.
So wait, so we're not just now, the way we get from 19 to 3, we're not just looking at this 1-hour snapshot inside the bubble, right? We're going backwards, before, outside the bubble. We're going after, out. So like we have 19 of them, and we follow them for like the next 2 hours. I'm like, oh wow, 2 of them drove 30 miles away, and then they were right next to each other. That's when you say evidence they're co-conspiracy meeting up. What you're talking about is following them after and outside the bubble, right?
Right, that's moving on to the step 2, location information. And
so we're not just looking at 19 people within this bubble during this hour. We're actually going back in time and looking where they were before, and we're going after and we're looking where they were after.
That's correct, Your Honor. The step 2 information looks at where they are over a 2-hour period, regardless of it. We start entirely with the set of people who are within the bubble at the hour of the crime, but then the step 2 contextual location information gives more information to law enforcement, which enables officers to have a better understanding of the role of people in what happened at the crime scene.
And when you think that you would need another warrant at that point, at each step?
I think it would be permissible to get another warrant, but I think it was a reasonable determination for the magistrate to make the determination initially that the 2 hours of location information about people who were present at the scene of the crime at the time of the crime was,
Yeah, but at
would be
step
evidence of
2,
crime.
he expanded the time and the location, I think is what Judge Hyden said.
Yes, and I think it was appropriate for the magistrate to make that initial determination that 2 hours of location information would be evidence of crime about people who were present at the crime at the
Were the
time.
counts identified by person, or were they still just numbers?
Step 2 continued to be anonymized number information. The only personal identifying information came in at step 3.
But wasn't the step 2 data sufficiently particularized that law enforcement could use public information to then cross-reference and individually identify those people at step two?
I mean, this step 2 tracked people's location for 2 hours. The defense.
So if somebody went into their home, the government could use property records to identify that person. If somebody went into a place of work, the government could use LinkedIn to figure out who works there. Isn't that right?
I mean, yes, certainly that kind of additional investigation would be possible, and it might be possible to identify people in some circumstances, but, you'd have, people don't only go into their own homes. Often, many people live in their own homes. But yes, it is certainly true that the step 2 information could potentially have been used through further investigation to identify people, so.
Now, these 3 steps, are they specified in the warrant?
Yes, these 3 steps.
You claiming that's specified in attachment 2
Yeah, the warrant,
at JA 110, 111? I mean, they aren't called step 1, step 2, and step 3, or vice versa. It's how called the place, person, or thing to be searched?
yes, it doesn't say step 1, step 2, or
It
step 3.
doesn't say.
But
The warrant doesn't say a
No.
thing about step 3, step 2, step 1. It doesn't say there's 3 steps. It has a bunch of bullet points, tells them what to do. And that was created by the court, based on the request for the warrant.
Yes, the warrant was issued by a court,
Yeah.
and it is, those are the correct record
Just want to make
citations.
clear that there's nothing in the warrant that talks about what you're talking about,
No.
step 3, step 2, and step 1.
No, it lists a series of bullet points which specify that process.
It would seem to me that it hasn't been much discussed, but the Miller and Smith cases have at least some applicability here. And I think it was in Miller, the government was making a request for bank records. And I would think that in terms of the privacy interest involved, that the request for one's bank records was frankly more intrusive than the request here. And yet even in the request of something, face of a request of something as personal as bank records, the Supreme Court said third-party search doctrine would apply and negate any Fourth Amendment violation. But those 2 cases, Carpenter never overruled them. Those 2 cases must have some applicability here.
Absolutely, Your Honor, and I'd like to point out a
And
couple
it's been
of.
surprising to me that we haven't discussed them, because the circumstances were really much more intrusive than what we're confronted with here. But the Supreme Court did not back off from the third-party search
Right, and
doctrine.
And both of those cases involve, businesses with access to large databases and having to produce to the government very limited sets of that information. I think it's worth noting here that this location history information that Google has is in fact a database that Google uses for its own business purposes. They use it to do targeted advertising. They use it to provide various services to the people who sign up, things like help with your commute, so it spots if there's a traffic problem at a place you're likely to go and tells you that kind of stuff.
But how does that differ from the data bank that many businesses compiled? I mean, a bank may not have the extensive database that Google has, but a bank has extensive data stretching well back. You can learn a whole lot more from a bank record about somebody's habits, somebody's financial history, who somebody's writing checks to, pay to the order of such and such. You can learn one heck of a lot about an individual and the way they conduct their lives by collecting their financial records and by collecting their bank records. And that's much more intrusive than what's at issue here, where we're talking about a limited public space and we're not divulging an individual's habits or friends or associations or what have you, and even in the face of a request by the government for the bank records, the Supreme Court was emphatic and said there's no violation. And I think we're bound to respect the Miller and Smith decisions because they have a very direct applicability, it seems to me.
I think that's absolutely right, Your Honor, and that goes to the fact that Mr. Chattree had no protected privacy interest in any of the information disclosed here. He disclosed to Google in order to obtain location-based services, and that makes it very much different than Carpenter, where the location information was just collected as a secondary background aspect of providing the communication service.
So can I ask you how far that goes? Does that include, say, hypothetically, my Google Photos account too?
I don't think so, Your Honor.
My Gmail account?
I'm not an expert on Google Photos, but I know with your Gmail, Google just stores your Gmail. They don't use it for any kind of business purpose at all. They don't even do targeted advertising for it. And so if you provide us just a pure storage service, I think it's not disclosed to the phone
Are you
company.
stating this for the record, or this is your opinion?
If you look at Google,
Are you stating for the record, or that's your opinion?
that's what Google says on,
Is that in the record? I mean, because we're deciding this case and you're asking you as if you're an expert. I mean, I just want to know, I'm not attacking you, I'm just saying, do you know, do you really know? Maybe, do you really know?
I mean,
You don't, do you?
is what Google says. You can read it online and their description of their services.
And that's what we're deciding this case on, what we can read on in the newspaper or online, internet. I mean, we're talking about the Constitution. The framers were some very smart people, to tell the truth. They didn't trust government. That's why we have such a beautiful Bill of Rights, and it says, no, you can't come into my house. No, you can't search. You gotta have probable cause. I don't care how much crime that occurs. I've never heard any court say because of the seriousness of the crime, we can just throw away the Fourth Amendment. But get to my question is this. When you actually have to search defendant here, it started with the geo-fencing and all those things, but what did you have other than just the start of it there in that fence, in that perimeter in terms of particularized crime, those three people? I just want to know, were they equally as potentially culpable, or that there was someone who just made a decision, well, this person here seems like a nice person, they live in a nice neighborhood section, this person doesn't, I'm gonna go after this person. I just want to know what was the metric? Because that's the detail, that's what the framers were talking about. That's what the difference in a general warrant. It's certainly a general warrant from the beginning. And you're saying it went down to step 1, step 2, step 3. But when the rubber hit the road, what was the particularized difference between, I couldn't get my 19-3 answer. So give me the 3 answer, 3-1. What's the 3-1 answer that made one person more particularized than the other than the fact that police officers sat around and said, based on what I know, the demographics of people, where they live, this person's unemployed, this person's race, this person's religion, I'm going after this one. That's what the framers didn't want done. That's why the Constitution stands as a bulwark. Tell me what made the 3 go to 1.
Well, as far as how they knew it was Mr. Chattree the robber, is that the location information in step 1 alone was sufficient when correlated with other evidence they had, like the videotape at the scene of the bank, to figure out that he was the robber. So that's how they
So
went.
you knew he was the robber then?
From step 1, and we've argued.
What about the other 2? Why were they still in the batch then?
What the investigators are going forward is to try to discern people's role in the crime, and so figure out, are they witnesses, or are they co-conspirators? And so it's not that people were assumed that they were guilty of anything in this. Remember, we're allowed to seize evidence of a crime, and that can include certainly who is a robber, but it's also potential witnesses. And really the key point of the narrowing down process is to try to determine who is what. And so they looked at things like, if you were on the scene for that whole first hour, 30 minutes before the robbery and 30 minutes after the robbery, you aren't going to be the robber or
And
co-conspirator.
that would be any innocent
You're
person
going
who
to
was
take
there.
off. Those would be
right?
witnesses.
That could be
Yes.
any innocent person.
It could be,
Right.
yes.
Well, that's the whole point. I mean, the net is pretty broad.
Again, it's appropriate under Zurcher v. Stanford Daily to collect, crime scene evidence and look for, to figure out who is, a potential witness of a crime. And we also have the Supreme Court case involved that says it's actually okay to put up a roadblock a week after a hit and run, at the side of the hit and run, for the purposes of finding witnesses. The Fourth Amendment permits us to look for witnesses.
Counsel, it may seem semantic, but I am just trying to figure out about the witnesses. I know the cases that say the police can look for witnesses. Are there cases saying the police can search someone on probable cause that they are a witness? 'Cause I'm not familiar with that line of cases.
So I would, I would say that Zurcher v. Stanford Daily is the case which says explicitly that in warrants to search for things rather than searching and seizings of people,
Right.
probable cause, you do not need probable cause for any third parties implicated that they're involved in crime. So Zurcher.
Right, and that's why they
is the
can
case.
search Google, but it just, assume hypothetically that I think once they start following those 19 people out of the bubble, seeing everything they've been doing for 2 hours, whether it's inside their own homes, in the church that's nearby, like wherever they are, they're gonna know where those 19 people are. If I think those 19 people were searched, is there some case I can go to that will tell me, oh yeah, if you're a witness, you can be searched?
I mean, not a warrant case, there's the traffic stop case, which I think
Yeah,
suggests.
but those were not searches, those were stops, and the court was very clear about this. This is the most modest intrusion. It's a stop, they're doing it to everyone, not to 19 people. They're doing it to everyone, it's a momentary stop. Nothing in that case says you can search the people in those cars.
Yeah, no, I just think it's in Zurcher v. Stanford Daily, you had searches of of every reporter's premises, and, none of them were involved in the crime, and the Supreme Court says that's okay. What matters is,
Counsel, what concerns me is, again, the sheer breadth of what is being proposed this morning. I wonder if we are not going down the road where any request from government, from any private company, is now going to be, for data from any private company, is now going to be constitutionally suspect, because every private company keeps data of some sort. And if we're saying that even data that's voluntarily provided, as it was here, to that company, if the government so much as requests that, then that's constitutionally suspect. And in most cases, the data would be provided to the government in a far less anonymized form than the government was provided in the early steps of the Google search. And if we say that even anonymized, largely anonymized data is constitutionally impermissible, then how much more constitutionally impermissible would be any government request from any private company for the data that they keep, all of those companies keep that data. And so the implications of this could not be more broad. There's nothing limited and narrow has been put before us. The propositions that have been put before us don't have an easy limiting principle. That's all I'm saying.
I think that's absolutely right, Your Honor. I mean, one example of this is if courts accept the Fifth Circuit's notion that it's impermissible for a private party to do a large database search before disclosing information to the government. I mean, that's what's traditionally happened with just telephone subpoenas, that when you subpoena a phone company for everyone who called a particular phone number, sometimes the phone company has to, query through every call in its database.
How is it different from Carpenter? I mean, where we are today, and again, I think this branch of government probably the least suited to address technological changes that are happening every day. And the kind of broad implications, we're moving into a world of AI. Every bit of that is going to be accessible by law enforcement, whether you use ChatGPT, Microsoft, partner, whatever you use. All that's continually mushrooming. The Supreme Court recognized it when it dealt with a case in which it said criminal defendants have wireless carriers of cell site location information. And as a result of that information, they were able to identify 4 robberies, which the circuit court said they upheld. The Supreme Court reversed. And even though you had 4 robberies that you could have stopped, and the Supreme Court reversed it, and it did it. It wasn't thinking about the robberies. It's thinking about, what did you just do? You went and accessed all of this cell site information on these individuals, and then you went and produced maps as to where they were, and then you identified the phones of these robbers. The Supreme Court said you can't do it. And yet we want to write ourselves around Carpenter and where this is going, because the implications here are far greater. But let me just say this. We don't have to even go here. We can deal with this situation as is before us. But as I said, in this particular situation here, Google isn't doing this anymore. Is that correct?
Google has announced plans. They announced plans a year ago.
You can't get this information from Google like this anymore.
You can still get it.
You say that's irrelevant.
It's obvious. I mean, it will have a perspective effect going forward. But Google.
You say that the government, the government and the court, that is the U.S. attorney and the grand jury, have done the same thing with the grand jury subpoena duces taken. It's not the same information.
Well, Google is changing the service, or
Well, I know.
that they won't have access to it.
Disinformation.
What?
The information, this was made subject to a search warrant, but hypothetically, couldn't the grand jury have issued the same request by way of subpoena and secured it?
I think, actually, because of the Stored Communications Act, probably not. The Stored Communications Act limits the scope of what the government can get pursuant to a subpoena.
Counsel, you were asked about, Judge Wynn mentioned Carpenter a second ago, and do you have a position as to why this case isn't prohibited based on Carpenter? Can you explain what's different about this, please?
Well, yes. First, Carpenter said to get a warrant to get long-term cell site information, and here we got a warrant. But also regarding why the third-party doctrine applies here when it didn't in Carpenter, the Supreme Court cited 3 reasons in Carpenter why the third-party doctrine wouldn't apply. First was that information was collected automatically simply by powering on your device. That's not true here. This requires an opt-in. Second, the Supreme Court said that you had no ability to delete your information when it was collected by the phone company. That's not true. Google explains from the very start, from its opening scene when you opt into location history, that you can go online and delete it at any time, and then it's quickly gone. And finally, they said that the cell phone use, the Supreme Court said in Carpenter that cell phone usage was essential to participation in modern society. Google location history is a nice little service. It provides a few useful features. It's not essential to participation in modern society, which we know because 2/3 of its customers don't opt into Google. So Carpenter does not at all.
What about the
include
factors that cut the other way? The fact that location history, in this instance, unlike in Carpenter, with the cell site, is collected every 2 minutes, automatically. And it's more precise. It's done within minutes. Cell site location is kind of all over the place. And unlike the cell site information, it follows these subjects right everywhere they go, even through walls and moving through private spaces. And then this geo fence is a sweep. It sweeps and gives you location information on an unlimited number of people who were previously unsuspected of anything. I mean, there are some factors here that cut both ways with Carpenter, but the end result is to understand where Carpenter and the Supreme Court has recognized where we are in this technological world. And if we write an opinion, we cannot do so devoid of the belief that it's not going to affect some other areas. It's affecting all kinds of technological advances, and even as we're speaking, it's changing right in front of us. And as I said, maybe we're the least suited branch of government to discuss this, because everything we're getting right now, we're just learning from the record and learning here. This is the most basic level of knowledge you can get on technology in front of a group of individuals who have probably no really technical experience of knowing where it's going and what's happening here. Supreme Court's very careful in doing with it. That's why increasingly courts are beginning to approach this subject very carefully. And because when you're seeking to the end result of solving a crime, the way to do it is just get rid of all the Bill of Rights. And you can solve a whole bunch of crimes. You just go around and you can torture, you can do all kinds of stuff. You don't need any rights to do that. But we got the Fourth Amendment. And if it's gonna mean anything, this movement in technology, and as I mentioned, AI, is huge. And there's no question in my mind, this is gonna apply to it. And to what extent are we going through an opinion here? You talk about broadness, it's gonna cover everybody, every phone sale, every time you get on a computer. You can't even look at a computer screen and say some words, and all of a sudden, you see the product popping up in front of you that you just were talking about. You didn't even write anything or say anything. And it's all there. All this data is there. And yet, the question is, why can't we get private businesses to give us this information on individuals? It doesn't mean anything until it hits home with one of us. And that may have been the case when you attach a GPS monitor to the back of a car. I mean, for the most part, it probably doesn't mean anything, but you begin to realize you could attach it to anybody. And that's what we're dealing with right here, is the broadness of where we're going with this. That what is wrong with just getting a warrant that's particularized? That's the requirement of the Constitution. Doesn't mean the police can't do the job. It means particularize the information you are seeking here, rather than searching in a broad sweep everybody out here until you finally get something and says, okay, good, they had this information all the time. If I told you, as I said earlier, if you look at the city of Richmond, you can say a crime is here. Well, we ought to search everybody in Richmond until we find out information that would implicate someone. And surely you cannot.
I think the warrant here is particularized because it's really quite similar to like getting video surveillance of the crime scene. And it was particularized by time and space in a way which appropriately narrowly linked it to this bank robbery. And
there's a big difference between a video surveillance, which shows you the exact people there, and this that has 592 million users in this this vault that Google maintains, for which then you got to use some methods to extrapolate what's going on in there. And I just told you, you could be sitting here talking, and if you say something like a car, that car pops up on the screen. It means they have the capability of finding out what you are doing every day. They can find out your religious activities, they can find out your sexual activities, they can find out everything about you. If you allow them to get into your data and go all the way to find out everything about a person. And that's where we are. And this is simply saying, well, just turn them loose. Let private industry just go in, pull up all the data, and when we have instances of things happening, we can locate it by letting them just do their thing, do the job of law enforcement. That's what the Supreme Court prohibited in Carpenter.
Again, Carpenter just said there was an expectation of privacy. It didn't address warrants. But I guess I'd like to address 2 points about why it's appropriate to do this with a warrant. One is that Google essentially does geofence warrants on its own as a matter of business purposes. The Call Federal Credit Union here could have done a radius, or could do a radius targeted ad for people who are within a kilometer of the bank, and Google would look through all of its hundreds of millions of customers and find that tiny subset of people who are close to the bank. And then it would use their location history afterwards and do store visit conversions to see if during some period of time they actually visit the bank. And to me, it seems like the government ought to be able to do, pursuant to a warrant, what Google is. Things what Google does is
reveal where your body is. They don't reveal the location of the person. They don't reveal the intimate details of the individual there. There's a difference in a bank record and what you're dealing with here. This does.
And the second point I'd like to make about why this is appropriate is that one of the, I think, fundamental Fourth Amendment rights shouldn't depend on a company's internal database practices and organizations. And here, the reason why Google has to filter through its entire database to find the set of people who were at the site of the bank during the robbery is because they've made an internal decision not to index their database based on location. They could do that if they wanted to, and then they would just be able to quickly, it would look up exactly who was at the site of the bank robbery at the time without having to do this big, computational
Mr. Judas,
process.
I don't see this in your brief, but do you know what happened in Carpenter itself when the case was remanded to the Sixth Circuit?
It was on, held up.
Did we suppress the evidence?
No, on good faith. So it was good faith reliance. And certainly, in this case, the good faith exception is another reason for this court to affirm the denial of Mr. Chatry's suppression motion. If you apply the standard Leon good faith factors, here the warrant was not so devoid of probable cause or particularity that officers couldn't rely on it. I mean, even the district court acknowledged that there was a fair probability that officers would be able to identify Mr. Chatry. As far as particularity, you look at the picture of the bank and the circle around the bank, and it's clear officers were trying to get information which is appropriately tailored to the crime here. And what's more, even
Mr. Judas, can I just sort of follow up on that in light of Judge Wynn's thoughtful remarks about the uncertainty of this technology, the perceived incompetence of judges in being able to deal with it, and the notion that perhaps what we need is a legislative fix and not necessarily a judicial one. And that gets to the point you just made about good faith. It seems to me that the easiest answer in this case is to leave this for another day and say that given the uncertainties of what the officers were faced with and the magistrate, they made a good faith effort to comply with the Fourth Amendment as they understood it. And even if they might have been wrong, they weren't quite so wrong that it warrants suppression, and leave this issue for another day.
That's certainly something the court can do, Your Honor. I do think in light of the Fifth Circuit's decision, some clarity on the validity of the warrant would be helpful to law enforcement going forward in this matter, because this, it impacts not only Google geofence warrants, which, by the way, I didn't answer that question earlier. They continue. We are still getting geofence warrants.
Well, we're not going to get clarity. We're just going to get, well, depending on how the court decides, we may get more confusion, not necessarily clarity.
Well, then there's a mechanism for clarifying beyond this court, Your Honor. So,
on the good faith question, you all argue the officers consulted with the prosecutors.
Yes, Your Honor, and that's important based on this court's previous decision in the McLam case. That
Yes, I agree. That's important.
Yes.
But did they consult with both the state prosecutors and the federal prosecutor?
I think the record says that the detective here had consulted with federal prosecutors on.
They consulted with the federal prosecutor?
On geofence warrants.
So that was with the United States Attorney in Richmond?
Yes, people in the United States Attorney's Office, they had consulted with.
I use United States Attorney, cover them all.
Yes,
They
yes,
all
Your
have
Honor.
48 Act for it.
Yes, Your Honor. And, even the Fifth Circuit, which obviously found and held that geofence warrants were unconstitutional, relied on this court's decision in McLam to hold that suppression was inappropriate for the geofence warrant in that case. So I do think it's appropriate here for this court to reject suppression based on good faith.
Thank you, Mr. Judas.
Thank you. We ask that the court affirm the district court's denial of the suppression motion.
Mr. Price?
Thank you, Your Honors. I just want to make a few points here. And I would love to talk a bit about step 2, because I think we spoke a lot about step 1. And even if you put step 1 aside here.
Who created the step 1, step 2, step 3 terminology?
I believe
It's
that-
not in the warrant.
The terms step 1, step 2, and step 3 are not in the warrant. Those are the terms that we've used to
I
describe
know.
it.
Who used? You say we used. Who created it? The prosecutors or the defendants or the judge? Or did it come out of, I don't know.
According to the record here, Your Honor, the geofence warrant process was created by
Google.
It was created by the Department of Justice and the Computer
Department
Crimes
of
and
Justice.
Intellectual
Okay.
Property section of the DOJ, working
Okay. Oh,
in
it's in a
concert.
DOJ policy.
It was the DOJ working in consultation with Google that came up with this.
So the DOJ and Google had already contemplated this and considered presumably the potential Fourth Amendment issues.
Well, I think that's actually very relevant here, Your
Yeah,
Honor,
I
because
don't say it's not relevant, I just didn't know where it had been created. I don't know if anybody said that. I knew that it was in the briefs, it wasn't in the warrant, I just wondered where it came from. And y'all were talking about it.
it's relevant here, Your Honor, because this was not a one-off situation where an officer just tried to do the best that he could under the circumstances. This was a pattern in practice. Geofence warrants began in 2016. By the time this warrant came around, there were about 25% of all warrants that Google got, and they're mostly using the exact same language. The Department of Justice created a template that was used in this case, or a variation of it used in this case, and many, many others. So to say that this was, just Officer Hilton trying to do his best, or he didn't know how many people would be searched, or didn't know how it was going to work, I think
Well, I mean,
rings a
did he
little
have any
hollow.
judicial authority or indication that there was something wrong with the use of the warrants? I mean, that it still was uncharted territory as far as the courts were concerned, right?
There hadn't been an opinion about geofence warrants, Your
Well,
Honor, but
that's
I
exactly right, and he went, he talked to the lawyers, he went before the magistrate, so to say that this has been around a while and he should have known better is just not correct.
Well, as a point of fact, Detective Hilton did not consult with prosecutors in this case. Apparently, he had obtained 2 geofence warrants prior to this case in which he consulted with prosecutors, but no data was ever obtained in those cases, and the detective did not, in fact, consult with prosecutors in this case.
Counsel, right before you sat down the first time, there was some discussion about whether your client had agreed effectively to the disclosure of this information, essentially the third-party search doctrine. And you gave us your position why you say you don't think that applies, why he hadn't really consented. Assume we disagree with you on that point. What's the implication of that to your position?
So I guess 2 things here. On the assumption, it's not my opinion that it was not meaningfully voluntary. That was the district court's finding as well. So
Yeah, we could debate that. I'm really trying to get to not that point. I asked you to assume it, not tell me why my assumption is wrong.
Voluntariness, in terms of the third-party doctrine, is only one prong. And I would argue it's not even the controlling prong. That's what Carpenter teaches us. So even if this may be slightly more voluntary than Carpenter was, you have to look at the nature of the data being searched. And
So you think even if your client, if we find he voluntarily agreed for it to go to third parties, we should rule in your favor?
I still believe so, Your Honor, even in the same sense that I voluntarily, store my Gmail with Google as well, but that doesn't destroy my expectation of privacy in it.
So imagine the most conspicuous warning in the world. Imagine that before you do it, like turn it on, and then it says, "Are you sure?" Big bold letters. Google is going to relentlessly data mine everywhere you go and keep it forever. Are you sure you still want to do it? And the box is default unhighlighted, and you hit highlight, and then it says, "Are you sure?" And then it says a whole list of things, and you say yes. You think even then?
No, I would agree with Your Honor that there is some form of language or warning here that could properly put people on notice about the scope and precision and relentless
So
collection.
you're saying in that situation, that consent would be fatal to your claim?
I think if you had a big warning and flashing letters saying, if you use this service, we're going to tweet out your location every 2 minutes, then.
Well, that's fine. So, but the implication of your argument then is consent matters. I mean, you got arguments why we don't have it, but you either have it at some point or you don't. There's either a decision on that or there's not, right?
So I think it matters in the sense that it's one of 2 prongs. It certainly, for the third-party doctrine, it wasn't, certainly wasn't determinative, not in Carpenter either. Mr. Carpenter signed a contract with the cell site company.
But the court said he didn't meaningfully consent.
In Carpenter, correct? And in
And so
this
if-
case, in the district court, found the
Right,
same.
but if we disagree and say he consented, I'm just trying to see, I mean, you got a lot of arguments why you went on consent, but it sounds like in Judge Hyten's example, you agree that if you do, if we're clear on that point, that's the end result of the analysis, then you can't prevail.
I think there is some level of warning that could, in fact, destroy your expectation of privacy. I do not believe that was the case here, and you absolutely have to consider the nature of the data being searched. Here, you know, just as
Yeah, I'm just trying to understand structurally. I got you. Thank you.
I do want to speak a minute about step 2 here, because we didn't get to that. And I do think it is exceedingly important to recognize the amount of discretion that law enforcement had at step 2 and at step 3 to decide who would have their data searched and seized further for an extra hour on either end. There was no process to go back to a court to obtain a second warrant. There was no judicial oversight for step 2 or for step 3. That is the kind of, and the district court called it unbridled discretion that this warrant granted to law enforcement here as the definition of an unparticularized warrant, where the judge is in some sense putting the rubber stamp on the warrant application, leaving it to law enforcement to exercise their discretion over what to search and seize. And I think that the other sort of important part to recognize about step 2 is the lack of anonymity in that data. Here we had some questions. Well, what happened to those 19? Who are those 3 people? In step 2, we actually had our expert at the district court level look at that step 2 data and identify people based on where they had gone. One of the individuals who was ultimately revealed here was
But
picking
wouldn't
up
that
her...
individual have to be the complainer? In other words, Mr. Chatry would have to complain that he was being identified in some improper manner.
Oh,
But the fact that it identifies, they've narrowed it down quite far. It's like investigating any crime scene. You try to eliminate people who are potential. Sometimes they're lookalikes. They have lineups. They have all kinds of methods for excluding people. But the Fourth Amendment is personalized to the person, his house, and his effects. And Chatry can complain. But it seems to me your argument isn't a complaint by Chatry, it's a complaint by one of the 3 third persons who were examined in that narrowed down process.
Mr. Chatry certainly is complaining here, Your Honor,
Oh, I
to be clear.
understand that.
But I think, and it did in fact track him to his house. In step 2, there are 4 or 5 little dots right on top of his address on Masondale Lane. So it certainly found him in a protected space. And I think, I'm sorry, Your Honor, I just blanked on your
No, you
question.
answer, you acknowledge what I think we agree on that. Thank you.
What I was going to say is I do believe context here matters. The nature of the search is something that can inform the court's consideration of it. In the same sense that, you know, a traffic stop may or may not be justified individually, but perhaps in a checkpoint situation, it's different.
Well,
So this is the opposite
My whole
here.
point in most of my questions has been, we're not in an ongoing search process. We're trying to uncover historical evidence, things, markers that were left behind. And in investigating a crime, investigators go various places. In the electronic age, we have these electronic data that historically preserve where this man was at a time and a place. The charge is that the search will go too broad, will get him at times where he's not even relevant or while he's vacationing or whatever. And my whole point has been that with respect to electronics, we've got to have a mechanism to narrow it down to what's relevant to the investigation of the crime. And in this case, it seemed to me that when the police said the crime occurred at a particular hour and we want evidence relating to that time and that place, and they made every effort to narrow it down to that, Mr. Chatry shouldn't be able to complain about that. It's a little bit like complaining about the fact that they test the gun casings or that they pick up fingerprints. Even though the fingerprints, he left those behind. If you accept the question that he left on his information on his service, that the location data, he left that on. And basically those are data that the police collected and helped identify him as the culprit. And it seems to me if we're going to take away that under some notion because the data bank is huge, that's a little bit strange, it seemed to me, didn't it?
Well, I believe that law enforcement should be able to access an individual's location history data. What we have here is akin to a digital all-persons warrant, like the situation in Ybarra,
No.
but digital.
No, that's just an overstatement. The investigation was of persons who left behind cell data within an hour in a circle of 150 meters. That is a very narrow request. They do not want 500 million people. They don't want people in Maine and Washington State. They want the people at that time and at that place. Now, that narrows it down enormously, but that's an investigative technique that we have to have in our society. Right. And the Fourth Amendment protects the person, his house, and his personal effects. It does not protect the government's going to other persons to ask about him. Where was he? Doesn't protect against them going to the bank and asking about that. It protects him and his person, property, and his house. And in that sense, he's entitled to have the search focused on where he was at that particular time and place. I don't know why we would suggest the data's complex now because it's electronic, but why we can't apply the traditional police techniques as long as we narrow the electronic data to what's relevant to a proper investigation.
Even if we put aside the search at step one, I think what we have here is, first of all, an incredibly broad geofence that covered not just the bank, but the entirety of a church next door. And if you consider the effective range of that geofence, how far they actually track.
He didn't go to his house. He robbed a bank. And they were trying to find evidence. Now, if he ran into the church for refuge, it would be relevant to ask the priest, did he come in here? Now, the priest may not say so. Or if his wife said he ran into the house and went up to the bathroom, they could ask her. But
obviously,
we have to start with normal crime investigation, and the Fourth Amendment protects. It doesn't protect you from committing crime, and it doesn't protect the government from collecting evidence about it.
I think there was, in fact, no indication that Mr. Chatry went into the church, which makes it all the more surprising that it was included.
That's a hypothetical issue in this case. We have a bubble created, quite a narrow bubble, about the time and place the bank robbery took place, a serious bank robbery. And whether he had compatriots or not, we didn't know. And so they finally, pursuant to a subpoena, they narrow it down to 3 possible people. At that point, a normal crime investigation would say, let's go talk to all 3 people and see which one's involved. They didn't have to do that because they had other data that they could cross-match. But quite apart from it, I'm just talking about normal police techniques. And the argument you're making to suppress the subpoena is that because Google has this huge data bank, that they had to go into their entire data bank to get this particularized information, it's therefore violates the First Amendment, it's too broad.
I think, Your Honor, again, even putting aside the first step, there's no indication that there was probable cause for all 19 people who had their information searched.
Those 19 people can complain. Mr. Chatry can't complain. He can't complain because they narrowed it down to where the crime was committed and the time it was committed. And he was a suspect. He became a suspect. So now if the other 18 want to complain that they were included in that bubble, let them come forward. But that's true in every crime.
I think Mr. Chaudhry is certainly complaining, and he is pointing to the broad nature of that search as evidence of its
That's
unconstitutionality.
what Carpenter
There
did.
was-
Carpenter looked at the investigative process.
Yes.
And whether the 19, it could have been 1,000, it could have been 100. And there was evidence of these people being in churches, they were in their homes, they were all over the place. You narrow it down to simply, if we get the guy, we only care as to what happened with this person here. That applies to anything else. I mean, that means just search everybody, and when you get the person, everybody else has no rights. Don't worry about it. We got your information of everything you've ever done on this thing because we got the guy and he can't complain. But that's not that way Carpenter worked. Carpenter didn't do that. It didn't attach a standing requirement based upon just that individual there. I mean, this is coming out of air from somewhere. It doesn't exist anywhere in reality. And the reality of where we are with this situation right here is this court can proceed as it will, but the technology will go where it's gonna go until it becomes evident that you will not have a Fourth Amendment right to basically anything in the direction we're headed. The Supreme Court saw it in Carpenter. Otherwise, everything that's been said here today, warrant, whatever, expectation of privacy existed, as they said in Carpenter, would apply in Carpenter. Why in the world would the Supreme Court allow you to get this cell tower information here to locate this individual, and then when you get it, he can't complain? Well, that's not how they did it.
I think that's exactly right, and this isn't, the privacy question is not one of a post hoc analysis where you see what got turned up in the search and then decide whether it's sensitive or not. You have to look at what the technology itself is capable of revealing prior to actually issuing that warrant. So the police didn't know whether there were going to be people in that church or not. They didn't.
And they didn't just search what he left behind, they also retroactively searched the tailing of the movement of these people. You had the 30 before, the 30 after. It's not just what happened there. It's not a video where you got nothing but what went on there. You got, these are citizens. I mean, this is.
Indeed, and in step 3, it wasn't Mr. Carpenter who was revealed. There was another woman who was picking up her child from school on her way back to their house. Another who was visiting somebody in a hospital who then visited the church. And those are the 2 people, in addition to Mr. Chaudhry, that made it all the way through to step 3. And you have to ask yourself, how did police get there? Because it was purely a matter of their discretion. There was no judge involved in that process. It was purely police discretion, and that is precisely
Didn't
the
the
kind
warrant
of...
authorize that process? I thought it laid out the details of the process.
The warrant laid out the 3 steps in this process. I think the warrant failed to inform the court of the nature of the search taking place.
Was the magistrate involved in step 3?
The magistrate was not involved in step 3.
That was all law enforcement, had nothing to do with the magistrate.
It was all law enforcement at step 3. It was all law enforcement at step 2.
That's what search warrants are, and they make them, when they're finished, they make a return to the judicial officer of the warrant and explain what they did.
The
That's what
warrant
it requires
return in this
return. Pardon?
the warrant return in this case was a single word, Your Honor. It said data.
But that's the return.
Well,
That's what they're
I
required
think
to
it's
make a return.
indicative of the lack of particularity in the warrant itself. The purpose of that return is so that the judge can check and see whether you followed the instructions in that warrant and whether what you took is consistent with what the warrant authorized. The reason that it says one word, data, in the return here is because the warrant itself was so amorphous and unclear about what was being searched and what could be seized.
Thank you,
I
Mr.
think-
Price.
Thank you.
Thank you very much for your argument. Appreciate the argument of both counsel. We'll come down and greet you and then continue with our cases for the day.
This honorable court will take a brief recess.
susceptible to discrimination against minority and foreign-born jurors. And we claim the government struck 2 jurors, jurors 217 and 138, because they were minorities and because one was foreign-born. And today I want to focus on all of the evidence of discrimination on this record, which discredited all of the government's excuses for striking these 2 jurors, leaving nothing but evidence of discrimination. So the government said it was concerned that juror 138 would not pay close attention because she did not answer 3 questions on her questionnaire. But the government accepted white juror 250, who wrote on her questionnaire that her loss of attention would interfere with her ability to be a fair and impartial juror. And she flat out said, "I just don't focus a lot, I lose focus a lot, and quote, it's a lot tough to remain focused for a long period of time." So the fact that the government accepted a white juror who obviously had trouble paying attention shows that its excuse for striking juror 138 was pretextual.
I thought they said for 138 that part of the problem for them was that this lady had grandkids that she sat every day, and that it would be very difficult for her to stay there weeks on end, and that would cause problems for her in the discharge of her duties. I don't think it was exclusively based on not answering a few questions.
Correct, Judge Agee. So, but juror 138 unequivocally said there was regular care in place for her grandchildren. Meanwhile, white juror 59 was uncertain.
Does that mean that even though she may have regular care, I mean, most of us up here have grandchildren, it's something that concerns you, and it may work good for a day or 2, but if you're thinking about doing it weeks on end, that's a different situation.
It may be, but again, you know, well, one point is if the government was truly concerned about that, then it would have followed up with additional questions if that was a genuine concern. But instead, it did not follow up with any questions.
Can I ask you about this argument that you're making about pretext with respect to inattentiveness and comparing the struck juror with the one who was kept? Was that argument made below in the district court?
That particular comparison was not drawn to
So
the
why
district court.
why would we even consider that now?
For a few reasons. 3. So there are 3 reasons why appellate courts must examine all the evidence of discrimination on the record, regardless of what was brought to the attention of the trial court. So first and foremost, because the Supreme Court tells us we have to. So in Snyder, the court held that all of the circumstances that bear upon the issue must be consulted, and the Snyder court explicitly addressed comparative juror arguments that were made for the first time on appeal. That's Snyder at pages 483 to 485. There's also footnote 2 of Miller L. The court explicitly rejected the dissent's call to find forfeited 3 arguments: the comparative juror arguments, the jury shuffle arguments, and the disparate questioning arguments, because the defendant did not make any of those below. The court said the evidence is what matters. If the evidence is in the record, we look at it. And then Miller L. was a habeas case, of course, where appellate review is generally more constrained. The Sixth Circuit in Atkins said that principle is even more true in the more permissive appellate posture of a direct appeal. Then this court followed Miller L. in Barnett, making it the settled law of this circuit. Even though the defense in Barnett had not made comparative juror arguments at the original Batson hearing, this court held that those arguments had to be considered on remand. That settled law continued through Foster, through Flowers, where the court repeatedly, over Justice Thomas's dissents as to preservation, addressed new arguments made for the first time on appeal. Second, we look at evidence, all available evidence, because eliminating discrimination is too important not to.
Let me stop you for a moment. So you're saying that in a case where the focus of the juror concern with respect to 138 was the child care issue, not the question of inattentiveness, and the judge decided the issue based on the child care issue, which was, again, the focus of the defense concern, to the extent that they raised a concern, that none of that matters. If you've got a new argument now with respect to inattentiveness and a comparative juror analysis, you can just, take a pass on that in the district court and then raise it here. Is that what you're saying?
No, absolutely not. And
Okay.
let me just set the record straight here a little bit, because the judge did not accept the child care excuse. So the judge did not credit that.
You're
because-
right, but my point is that was the focus of the concern, and now you're raising an entirely different concern.
Well, the government gave two reasons. Both are discredited. And
The district court did not accept them for purposes of disqualifying the juror for cause. I don't think that's the same thing as saying it's discredited when you're looking at the pretext context.
also, let's set the record straight. The government never moved to strike either one of these jurors for cause. They didn't strike.
Well, they may not have, but if the district court felt that this was a characteristic of this particular juror that would prevent them from discharging their duties, he could have struck them for cause, and he didn't. My point is that I don't think you can carry over a determination on cause, even if it's implied, to say that's almost an estoppel on the pretext issue.
So let me point you to some language in Snyder. In Snyder itself, the court said, we recognize that a retrospective comparison of jurors based on a cold appellate record may be very misleading when alleged similarities were not raised at trial. In that situation, appellate courts must be mindful that an exploration of the alleged similarities at the trial have shown that jurors in question were not really comparable. In this case, however, the shared characteristic, i.e. concern about serving on the jury due to conflicting obligations, was thoroughly explored by the trial court when the relevant jurors asked to be excused for cause. The same goes here. These things that I'm pointing to were thoroughly evaluated by the district court in his questioning. So there's juror 59. In terms of the child care excuse.
Well, it seems like the thrust of your position, maybe I'm overstating it, is that if there's not a basis to discharge for cause, then that's a prima facie evidence that there's pretext, at least in this Batson context.
There could be, right? I think it's a factor. So if the government had been genuinely concerned about juror 217's ability to deliberate with other jurors, for example, it would have moved to strike that juror for cause. That's the mechanism for getting rid of that juror. You would not waste a peremptory challenge on such a juror. For example, a juror who was hard of hearing. The proper mechanism for getting rid of that juror would be a motion for cause. The fact that it did not hear speaks volumes, along with the fact that the court reporter, all defense counsel, and the judge could hear and understand juror 217.
Let me rephrase my question, because maybe I didn't make it clear enough. I understood this record, and you can correct me if I'm wrong, as showing that with respect to juror number 138, the defense never made an argument that the government was striking, the government's rationale for striking the jury was actually a juror, was actually a pretext for discrimination. Do I have that wrong?
Yes, because, the way it went was, there was the prima facie case, there was the government's reasons. Then the judge immediately asked both counsel, was there colloquy in terms of arrangements for these children? The defense says yes, the government says no. The court says, let me check my notes, checks with his clerk. Yes, there was. Okay. So then the judge goes right into the ruling and says, I do not credit the child care reason because our notes indicate that the grandfather was available, but I do credit the failure to answer the questions shows a lack of attention. The defense really didn't even have an opportunity, but the argument that the notes that the grandfather was available is an argument that excuse is pretextual. That is an argument. There is no magic word requirement in Batson that you use the word pretextual. The whole point of the Batson objection was that this was pretext for intentional discrimination.
Well, it seems like you're back to what we discussed before, that in effect, denial for cause is prima facie proof of pretext.
It can be. And I think on this record, if you look at it in conjunction with everything else that's going on, it was. So Juror 59, for example, was uncertain whether he would be able to find care for his wife during her recovery after a scheduled knee replacement, but the government accepted him. That comparison also shows the government's child care excuse was pretextual. The government misstated the record of Juror 217's voir dire. Now, the government concedes it was wrong to claim it moved to strike Juror 217 for cause because it didn't. Now, the government also claims in its brief that it could not be sure that the other jurors would take the time necessary to understand Juror 217's accent. But the government was okay with other jurors having to take extra time to ensure that white Juror 250 understood everything. Let me point you to Joint Appendix page 627. So in denying the defense motion to strike Juror 250 for cause, the district court said, quote, her reactions and responses were not as immediate, maybe not as sharp as was true with some of our other potential jurors, but really with just a minimum of additional follow-up and prompting from the court and a little bit of additional effort to explain a question or concept, the juror was able to comprehend and understand, etc.
But
That inconsistency.
That's the explanation for rejecting the challenge for cause, but then you've got to deal with the basis for peremptory challenge where the court said, with respect to Juror 217, if I have the number correct, that, I don't necessarily agree with the government. I think that with some effort, I was able to finally understand that particular juror, but I don't find that explanation ridiculous, or I guess I don't find it to be a pretext. It's a different test. Don't you agree? I mean, so long as the court finds that the government wasn't acting with an ill motive, a discriminatory motive, you can argue about whether or not peremptory challenges are a good thing. Frankly, I think they're likely not, precisely because we have to deal with these issues. But if we have them, and if the government can show that notwithstanding the court's disagreement or the fact that another juror was not challenged for cause was not granted, if they can show that in their mind, in good faith, they don't think that this juror would be ideal, in part because they think that he might have a difficult time engaging with the other jurors and vice versa. If that's a legitimate rationale, how is that possibly how can that possibly be an abuse of discretion for the judge to grant the challenge?
But here, the district court did not credit the factual underpinning of the government's only reason for striking Juror 217, his accent. That is more evidence under St. Mary's versus Hicks. That's evidence when the district court discredits one of the reasons. Same for 138. And the accent excuse itself here, it's important to recognize, is direct evidence. This is not just purely a circumstantial evidence case that we're building. That is direct evidence of discrimination. The Sixth Circuit in Inri Rodriguez held that an employer's comments about an employee's accents are direct evidence of national origin discrimination, and the same goes here.
So you focusing on 138 or 217? It
Both.
seems like you're sort of going with both. I think you have to separate those two. And I'll tell you, I've been looking at Batson challenges for over 30 years as an appellate judge. There are all kinds of reasons that are given by prosecutors, and rarely, if ever, have I seen one like this not being allowed. But I think you have to talk about these two jurors separately, because they're two separate things. One's under national origin, the other one you're dealing with it from probably a race-based situation. 138, if I had to pick, it sounds like to me is probably the weaker of the two arguments you could make on this. And the reason I say it is she didn't answer the questions, and maybe it's reasonable for a prosecutor to ask, since you didn't answer 3 of the questions here. Even with the child care, which the court sort of delved into, she has to take care of them all week long or something. And I mean, yeah, husband can babysit at times, but it may be a concern, how much you're gonna be there. But in any event, I think you need, I would suggest, it seems to me, you need to address these separately. They don't, in other words, you can't lump them all together, because you're sliding back from one to the other, and frankly, it's confusing me, because I think your basis have to be for each juror, you've got to stand on that one.
And could I have a little leeway to respond? I know I'm out of town.
Absolutely, go ahead.
Thank you, Judge. Well, neither strike can be reviewed in isolation, I think, because of Snyder, right? Snyder says pretextual reasons for striking one juror are probative as to the other. And so that's why I am bouncing back and forth a little bit. But I also want to make it clear that race is a basis for both jurors. You know, with the accent, this is a black Nigerian man's accent, so race is necessarily involved here. So I do want to just make clear that this is both race and national origin as to 217.
Did the prosecutor state the reason because they had a Nigerian accent, or was it a strong accent?
It was an accent that was strong. It happened to be a Nigerian accent.
Happened to be, but it wasn't his reason for giving. And I'm wondering, you know, I've heard many accents. Sometimes a southern accent can throw me off. And how is that different if you say I can't understand because of the accent?
So accent
But I
could,
didn't hear the word Nigerian on it, which, you know, brings in a national origin. I mean, contextually, yeah, we know he is and was there, but that's not the reason he gave. He didn't, unlike the cases where you had the Hispanic cases, they gave that reason. He had a Hispanic accent on it. Courts have said, no, you can't do that, because it seems to discriminate based upon the national origin, that he has an accent of that. But a strong accent is, this guy's been around in the United States for 25 years. He had all kinds of degrees. He's smart as all can get out. I mean, I don't know what his accent sounded like. Could have been more, I would probably say probably more British than it was anything else. And it could be difficult, but the court did at some point say he could understand them. I mean, it may have taken a little work to do it. So, you know, I'm just trying to follow in terms of if your basis is national origin, to what extent do we rely on what the prosecutor actually said as opposed to what the record reveals about him outside of that?
right, I just don't think we can ignore the fact that it was a Nigerian accent in this situation. I think there could be situations where an accent, whatever it may be, maybe a southern accent, is too difficult, and that could be the reason. But here, there's an entanglement, and this is all the scholarship we cited in the briefs. There's an entanglement, and especially when you look at the employment discrimination cases, they're really instructive as to looking to accent.
I just want to make sure, because I think that's a distinction. You cannot ignore the fact it was a Nigerian accent. There's evidence he was Nigerian. There's evidence he has a strong accent. How does that add up to the conclusion it's a Nigerian expert?
Well, the defense argued that it was a Nigerian. They said
That's
he
your
had
argument, but I'm talking about in terms of you focus on the reason that's given here, and you say it's pretextual. But if it's a strong accent there, and I got it, more likely it could be a Nigerian accent, but that's different from a lot of people have strong accents. Doesn't matter where you're from. That's not a national, or strong accent doesn't necessarily refer to a national origin. Agree?
Correct, because you need to know, what kind of accent, and here the record reflects that it was because he was Nigerian. I
All right,
don't want to
Counsel,
abuse
yeah.
my
You've got some
my
time
privilege
left for
here.
rebuttal.
Thank you, Your Honor.
Mr. Smolkin?
Thank you, Your Honor. Good morning. May it please the Court. Anatoly Smolkin on behalf of the United States. After presiding over 4 days of jury deliberation in this case, observing each prospective juror and all of the lawyers in the courtroom, the district court made factual findings and credibility determinations, concluding...
You got two situations here. You got two jurors, stricken, 217, 138. And I don't know about my colleagues, but I think we could just deal with the issue here in this case, which is, were they properly struck, the peremptory challenges, or was this pretextual? And I think, I agree, I think it should be separated. I think you've got to look at that 217, because I think that's, it looks at me as pointing to national origin. And you heard my colloquy in terms of, is this because he's Nigerian? Would you not agree that if the prosecutor has said he has a strong Nigerian accent, that is probably violative? Would you agree?
I think that if that were the only basis given, if the basis was, and this is not the case here, Your Honor, but if the basis was the prospective juror has a strong Nigerian accent or a strong foreign accent, and for that reason, we don't want that person to serve on the jury, then that's a problem.
That means everybody with a strong accent from Nigeria couldn't serve, wouldn't it? Because if that's a basis, it'd be a basis to strike anybody with has that.
If it were a basis, then sure, it could be applied across the board. But I think that it's important to focus in on the specifics here, which was not that his accent existed, but that his speech was extremely difficult to understand. And whether that's by virtue of his accent or some other reason, the government's basis was the difficulty in understanding the way that he spoke. It was not because of his accent. It was he spoke in a manner in
which would go to this juror's ability to interact with the other jurors and whether or not they would be able to discharge their duties in conjunction with him if they couldn't understand him.
That's exactly right, Your Honor. I think that serving on a jury certainly has the component of receiving the evidence, right? Hearing the evidence and understanding it and digesting it. But obviously very important secondary component, arguably more important, is deliberating. Going back to the jury room and interacting with your colleagues about what the evidence showed, what the evidence didn't show, and whether the government has carried its burden beyond a reasonable doubt.
It's really hard to believe this man couldn't interact. I mean, he'd been here 25 years. He has degrees, nuclear type degrees, all kinds of stuff. And I mean, it just seems like if he could function in this country for 25 years, he can talk to people. I mean, maybe that's the basis of it. But I think when you're giving a reason by the prosecutor, and what I've seen over the years, it looks like you can just about say anything in some of these cases that I've seen come up. But in this particular instance, it would seem there are cases that are dealing specifically, and the ones I've seen have been mostly on Hispanic, where you do not want to strike them simply because they sound Hispanic or they sound Nigerian. That seems offensive. But to say he has a strong accent, I can see your point. In other words, that he wasn't easy to understand. And the question is that sufficient as a reason so as it's not pretextual? Doesn't mean it's a good reason. It's just not pretextual. It means, yeah, you know. And what you probably can point to is the number of times the judge had to keep asking. That might be helpful.
And Your Honor, that's exactly where I was going to go next. You know, there are sort of two points in the voir dire colloquy that we should focus on. The first point was prior to the district court asking the juror to move closer to the microphone. That took up less than a page of transcript, and during that exchange, the district court needed 5 separate times to repeat or clarify what the juror said. So then the court asked, please move so that your mouth is 1 inch from that microphone. And for the next several minutes, there were 29 separate times where the district court needed to repeat, confirm, or ask a clarifying question.
Well, he did have a mask on. He did have the mask on because he hadn't taken the COVID vaccine, so he had to wear that mask. And I can imagine that's really difficult to hear. I don't care what your accent is.
He did have a mask on, Your Honor, and I think that there were certainly other jurors who wore masks during the course of voir dire, and the defense certainly points out that there were a few interactions with the district court where the judge said, please repeat that, or I didn't quite understand you, with other jurors. But nowhere comes close. None of those other interactions come close to the 29 separate times that the judge needed to clarify or repeat Juror 217. And I'll point the court to just a couple of examples here. One was Joint Appendix 554 through 555. The court was asking about the juror's children. He said, are they still at home with you? The juror said, no, they're in college. The court said, I'm sorry? The juror said, they're in college. And the court had to confirm they're in college. Then when Juror 217 was explaining that he used to work in Randallstown for a company called Jackson Hewitt, the judge said, you worked at, say that again, please. The juror said, Jackson Hewitt, the tax, to which the court responded, taxi. and then there was a further exchange during which the court needed to clarify exactly what the juror was talking about. So I think that to the extent the appellants argue that the record doesn't support the government's observations, the record absolutely supports it. Not only that, but the court actually made observations consistent with difficulty to understand this juror. The court said at Joint Appendix 560, I have had some difficulty understanding him as he spoke with his accent, but with some patience and clarification, I think it's all come through. Then at Joint Appendix 1416, the court says, I didn't detect a hint of a problem with his actual use of the language once I could penetrate the accent and understand it. And then at Joint Appendix 1418, the court indicates that he could understand the juror, particularly if I was prepared to make an effort to really try hard to listen to him. So I think that these observations by the district court in overruling the Batson challenge go exactly to the heart of what the record shows here. The record shows that, in fact, there were difficulties here. There was a problem with understandability. And again, it's not because he had an accent that he was excused with a peremptory challenge. It was because of the concern about his ability to effectively deliberate with his fellow jurors, which is a valid and legitimate basis, of course, for the government. It's a valid basis that the government has to strike a juror with a peremptory challenge. And I want to touch on something that Judge Agee brought up with respect to this distinction between a cause challenge and a peremptory challenge. There were moments where the district court, and this is highlighting what the defense calls essentially a disagreement with the record, or I'm sorry, with the government's view, that the court rejected the government's interpretation. I think what the court was doing was, he said, I disagree with the government in terms of his suitability for jury service. That's a cause type analysis, whether someone is suitable, whether someone is qualified to serve on a jury. So the district court believed he was qualified, certainly. And he disagreed that the language, the understandability was so problematic that it would disqualify him from service. That's on the one hand from a cause analysis. On the other hand, there's the peremptory analysis, which is much different. And so as long as there's a legitimate, non-discriminatory basis, the government is entitled to exercise its peremptories. And the judge here found that the motivation behind the peremptory challenges had nothing to do with race, nothing to do with national origin. The court found that the concerns were genuine, valid, and not rooted in these factors that the appellants now claim were all over the record in this case. And I think that goes to a point that Chief Judge Diaz brought up, which is, should this court even engage in this type of analysis, given that the arguments were not raised below? And I want to make a couple of points in that regard. I think, first and foremost, to the extent that the record is fully developed on these particular issues, the court can engage in some of this analysis. That's what the case law says. Now, the Fourth Circuit does say that failure to argue a specific basis for pretext may constitute a waiver of the ability to make that argument on appeal. That was United States versus Chapman, which is an unpublished decision from 2006. There's also United States versus Bell, another unpublished opinion from 2013 of this court, that holds that a defendant is required to identify comparative jurors below in the district court as a condition of raising the argument on appeal. So I just want to say there's very good reasons for that general principle, and that is that if you fail to argue below, for example, a comparative juror type analysis, it prevents the government from creating a record explaining either why the jurors were not similarly situated, as is now being claimed on appeal, or why the jurors were treated differently but for permissible reasons. So I think that Juror 89 is a perfect example. And the appellants don't argue about Juror 89 anymore, because after their opening brief, I gather they realized that there wasn't this discrepancy. But the claimed discrepancy was that Juror 89 also missed several questions on his answer sheet. The factual record, as we've explained in our brief, does not bear that out. He did not miss any of the questions. But the point I'm trying to make is, had that argument been raised below, the district court would have simply picked up Juror 89's answer sheet, would have looked and confirmed, in fact, Juror 89 answered every single question, and he was not a comparable juror for this type of analysis.
You cited two unpublished decisions from our court with respect to this requirement of preservation, but your colleague on the other side rattled off a number of Supreme Court cases and other cases that seem to suggest that, at least in this context, the courts are not so concerned about strict preservation so long as there's sufficient information in the record to consider the issue. So do you disagree with his characterization of those cases?
No, I think there's a distinction with several of those cases, Your Honor. First, with respect to Miller L. in particular, that was the case that established for the first time that comparative juror analysis should be considered at all. So it makes sense that it wasn't argued below, but then was permitted to be argued above once the Supreme Court ruled that it's a valid basis or a valid tool for courts to use in wrestling with this analysis. I think Barnett was in the same boat. The Barnett case, the original Batson hearing was before comparative juror analysis was permitted by the Supreme Court in Miller L. And so on remand, this court authorized or instructed the district court to consider that argument below, which makes perfect sense. I guess what I'm trying to drive at, Your Honor, is that this court's not prohibited from considering these issues only if they've been fully developed below. Obviously, the best way to fully develop an argument below is to make the argument below, which did not happen here. But the cases, and I'll refer to United States.
When you say that did not happen here, are you saying it did not happen with respect to both jurors, or juror 138 or 217, which, what do you mean?
What I'm saying, Your Honor, is that a number of the arguments being made on appeal were not raised below, and so the record as to those arguments.
Well, let me focus on 138, because my understanding of juror 138 is that the whole focus was on the child care issue, and the judge resolved that issue and then moved on, and no one raised any kind of contention that there was some pretext on the part of the government in striking the juror. Do I have that right?
That's exactly right.
So is that forfeited?
I think it is.
Okay.
That's forfeited under this court's decision in Davis versus Baltimore Gas and Electric. And that goes beyond just the failure to make particularized pretext arguments below. That was just a complete failure to argue any pretext, to argue that the government's stated basis was masking discrimination, which is the burden ultimately that the defense has to carry to sustain a Batson violation. So with respect to juror 138, the government's primary reason, of course, was the failure of this juror to answer 3 questions on her questionnaire, and also that while the court walked her through those answers, she displayed a lack of interest in the process or a concern about the questionnaire. That was our primary focus. And when the court said, well, remind me of who this juror is, he said, help me remember who she is, perhaps describe her job or her situation. That's where the child care colloquy came from. So it was a secondary basis that the government relied on, but primarily the basis for striking juror 138 was the lack of answers on her answer sheet and her general disinterest in the process when the court walked her through those answers.
And even if we were to consider that issue, I guess, to the extent that other jurors may have failed to answer questions, you may dispute that on the questionnaire, but is there any indication in the record that they exhibited the similar indifference or lack of interest that somebody, maybe not you, but the government highlighted in the district court?
No, not at all, Your Honor. There was only one other juror who missed any questions, and she was ultimately seated as one of the alternates. This was juror number 454. Her voir dire is at Joint Appendix 1343. And in her case, when the district judge brought to her attention the fact that she missed 1 or 2 questions, it was as if she was mortified. She said, oh, I'm so sorry, I didn't realize, and she engaged with the court. She interacted with the court in a way that you would expect someone to interact who is engaged in the process and who is not demonstrating a disinterest in being potentially seated as a juror. And this particular juror was actually a black female that the government did not strike, the defense did not strike her. But when you look at the joint appendix, it speaks volumes in terms of just what her reaction was when sort of confronted with the fact that she missed a couple of questions. There are no other jurors who stand in that position either. I just want to make a couple of additional points. So with respect to these waiver and sort of procedural arguments that we've made, I just want to be clear. We're not hiding behind those arguments to say that the court, if it delves deeper and examines the merits, that there's going to be some problem. So I'll take on these specific comparative juror analyses that are raised for the first time on appeal. I'll start with juror 59, who was the individual whose wife was scheduled to have knee surgery. The colloquy in that regard was that he would need someone for a couple of days to potentially help take care of his wife while she recovered from outpatient surgery. This is much different than.
And that, is this a comparison to 138?
It is, Your Honor, I
Okay.
apologize. And in fact, Juror 59, when asked if he would be able to get someone to cover, he said, I feel pretty confident we could find somebody. Again, this was a potential short period of time here as compared to Juror 138. I've already discussed Juror 89, who did answer all of his questions on the answer sheet. And then Juror 250, which the defense spends a little time on. The argument there is that I guess if the government was so concerned with inattention, it would have struck Juror 250. Well, there are several reasons why Juror 250 was not struck. The first was she was fully engaged with the district court during her voir dire, unlike Juror 138. She also confirmed after further questioning that she doesn't think her difficulty focusing was any different really than anyone else, and that she wouldn't be worried about her ability to focus during the trial. And also, and perhaps most importantly, the defense unsuccessfully moved to strike her for cause. So when deciding what peremptory challenges to exercise, the government knew that the defense was likely going to use one of its peremptories to challenge Juror 250. And so for that reason, we wouldn't have needed to use a peremptory to make that challenge. I'll also point out that the defense argues that if we were concerned, and now I'm shifting to Juror 217, the individual who was difficult to understand, the defense points out that we would have moved to strike him for cause if we really had difficulty understanding him. And I would just point the court to page 560 of the joint appendix. It's at that point where the government asks the judge to ask a few follow-up questions to explore his sort of language skills just to see what else can be learned. And the court says, well, I'm not really sure it's going to reveal anything. And the judge says, I've had some difficulty understanding him as he spoke with his accent, but with some patience and clarification, I think it's all come through. And then this is important. The judge says, so I think that is what it is, and I don't find that to be disqualifying. So effectively, the district judge has ruled on a cause-type challenge. He's ruled that it's not a disqualifying factor. There's no reason at that point for the government to come in and say, well, judge, to be clear, we move for cause, when the district court has already essentially ruled that that challenge would not be well taken. I'll also point out, Your Honors, that even the defense got it wrong in terms of what Juror 217 said during his interaction with the court. This is at Joint Appendix 1417, where one of the defense attorneys had said that Juror 217 lived in Manhattan for 4 years. Well, the juror said he lived in Baltimore City for 4 years. There's no mention of Manhattan at all. He also said that the juror lived in Randallstown for 13 years. Well, there's a colloquy where the court clarifies, was it 13 or 14? They ultimately land on 14, but defense counsel thought it was 13. And then finally, defense counsel says that this juror had 4 children and their ages were 26, 33, 18, and 17. But what the juror said was they were 26, 23, 18, and 17. I bring this to the court's attention just to address this argument that the defense has made that the record is devoid of factual support for the government's basis. I think the record is replete with support here that the juror was difficult to understand and that the government's basis for its strike was well taken. And I just want to sort of bring it back here. I'm sorry, Your Honor.
Sorry. For a moment there, I thought you were going to argue, and maybe you tell me if this is an argument that you support, and that is that those misstatements also suggest that anyone can make a slip of the tongue in the heat of battle when it comes to selecting jurors, because I understood that to be an argument as well, that the government misrepresented a number of facts throughout the proceedings regarding what jurors said or didn't say. So you think that's relevant, that it can happen to anyone?
I certainly think it can happen to anyone, Your Honor, that in the heat of battle, like Your Honor just said, that there can be a slip of the tongue. I think to address the specific argument that the government misstated numerous facts, I think that's not supported by the record. The only misstatement which we acknowledged was that we didn't actually move to strike Juror 217 for cause when we mistakenly thought we had. And I think the representation was, I think we had an extensive discussion on a strike for cause with this juror. That turned out not to be the case, but as I've just explained, the court essentially took on a cause-type analysis. So I appreciate Your Honor's point that it could have been a slip of the tongue, but also in this context where the government is being accused of racial and national origin discrimination in the selection of a jury, and when our basis goes to the very heart of understandability of this juror, I think it's relevant that the defense, in arguing their Batson challenge, was not able to understand that juror perfectly, even though they claimed that they could. And I know that I'm just a bit over time, if I may briefly conclude, Your Honors.
Go ahead.
I would just like to kind of bring it back to what Batson is getting at, and it's getting at purposeful racial and national origin discrimination. And here, there's deference owed to the trial judge who sat through 4 days of jury selection, observed the demeanor of all the lawyers in the room, and made credibility determinations and concluded that there was no racial or national origin animus in the government's strikes. This court held in Evans versus Smith that those credibility findings are owed great deference on appeal. I think that given where we are with a clear error standard, the facts that the appellants have tried to marshal here simply don't rise to the level of showing that the district court clearly erred in these factual findings and these credibility determinations. So unless Your Honors have any other questions, I'm happy to sit down.
Thank you very much.
Thank you.
Thank you, Your Honors. As to Juror 138.
Let me ask you before you get
Yes.
started. You did not discuss the 11-person jury argument earlier, I don't think.
No, we're relying on our brief on that.
Okay.
Davis versus Baltimore Gas as to Juror 138 is absolutely distinguishable. In that case, in Davis, the district court did not make a step 3 ruling. Here, the district court did. Also, the defense argument about the grandfather was an argument about pretext. The defense did not stand mute like in Davis. Then there's also the fact that Davis predates Miller L., Snyder, Barnett, and all of the Supreme Court's Batson jurisprudence. I also want to point out that the two of the questions that Juror 138 missed were actually conditional, and the condition didn't apply to her. So if you look at it carefully, they asked, if you have previously served as a juror, would that experience affect your ability? She didn't answer them because she'd never served on a jury. So she's actually being quite careful with the wording of the actual question. I also want to talk about the two other reasons for why this court looks at everything on appeal. And one is, an example is Pena-Rodriguez versus Colorado, as just one example, where the Supreme Court said there's an exception to the no impeachment rule for jury deliberations when it comes to racial bias. It's just discrimination is different. Third, Yee versus City of Escondido and all of its progeny. So in Yee, the Supreme Court held that once a party has properly presented a federal claim, quote, a party can make any argument in support of that claim. Parties are not limited to the precise arguments they made below. And this court followed that in Ortiz-Orellana, Henderson, Robinson, all cited in our brief. I also wanted to read just one other juror. There are several, but I just wanted to read one other juror's colloquy to show how similar it was to Juror 217's. This is from Joint Appendix page 785 and 786. My friend Brianna was murdered. The court. Now, I can't quite hear what you're saying. Prospective juror. I'm sorry. My friend Brianna was murdered 2 years ago. The court. Your friend Brianna was murdered 2 years ago. Where did that happen? Prospective juror. In the city. The court. In Baltimore City? The prospective juror. Yes, sir. Court. And do you know, prospective juror, she was coming home from work from the bus stop. The court. She was coming home from the bus stop. Prospective juror. Court. Do you know anything about the circumstances beyond that? I know that she was stabbed. The court. She was set up? Prospective juror. Stabbed. Court. She was stabbed? Prospective juror. Court. Okay. Do you know what part of town it happened in? Prospective juror. Park Heights? Court. In Park Heights. This was the MO of this judge to make sure that he was understanding jurors because of all the obstacles to understanding. Masks, plexiglass.
Did Judge Berdar make an affirmative statement as to this juror and a difficulty understanding as he did with juror 217?
Yes, that's actually riddled throughout multiple jurors. And in one instance, the judge not only says, get to 2 inches, he says, put your lips, please, on the microphone. And that actually is, there are multiple places in the record, if you look, they're there. I do want to briefly touch upon the probabilistic nature of a Batson claim. You know, a party doesn't have to prove intentional discrimination beyond a reasonable doubt. A party doesn't have to prove it by clear and convincing evidence. A party has to prove it by a preponderance. In other words, a 51% chance that the government strike was motivated in substantial part by discriminatory intent. Now, substantial part is another probabilistic aspect to the standard. So putting it all together, a finding of discrimination under Batson is really a finding that the risk of discrimination is just too high to be tolerated. No one has to be labeled a racist to win a Batson claim. But just to conclude, at the end of the day, this case really comes down to whether, after reviewing everything, you firmly believe a mistake was made and these 2 jurors should have been allowed to serve. Both were willing and able to be fair and impartial jurors. Juror 217, a naturalized citizen, drove 2 hours a day for 4 days, showing up early every day for COVID testing. They should have been allowed to serve, and because the district court denied them that right and duty of citizenship, appellants must receive a new trial. Thank you.
Thank you very much. I want to thank both counsel for their fine arguments. We'll come down and greet you and adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.